Azaria and Ferrari reporting live from the Fulton County Superior Courthouse for the bond hearing of murder suspect Vincent Hardeman, aka rapper Young Vito. Today the judge made his ruling whether or not to grant rapper Young Vito bond regarding the murder case, which will be scheduled February 18th in the killing of rapper Slim Duncan.
Remain seated. Court come to order.
Good afternoon.
Good afternoon.
This case was originally on for trial this week, and the state couldn't find two witnesses. Is that
Your
correct?
Honor, if I may, this is indictment 12 SC 108936, the state of Georgia versus Vincent Hardeman. Vincent Hardeman has been charged with 1 count of malice murder, 1 count of felony murder, 1 count of aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony. The defendant is present in court, represented by counsel Mr. Hirsch. Your Honor, yes, this case had been set down over the state's objection for December of this year. The state had vehemently objected to being called into trial so soon on the case, and the court graciously continued it from December 3rd until December 17th today. Last Friday, as we were afraid, a few of our witnesses, 2 main important witnesses, basically refused service and were evading coming to court to testify. Now, Your Honor, in a case such as this, one of the concerns with any defendant and his associates are the intimidation of witnesses and trying to keep witnesses from coming to court and not testifying. And so we had that very, very problem in this case. So the court graciously granted our continuance in an effort to get us some time so that we could go ahead and have these witnesses served with subpoenas. And I believe today's purpose for the court was to go ahead and give us another trial date, a date certain, so that we can subpoena these witnesses with subpoenas for the future court dates.
And we did try to accommodate the defendant and put it on for trial as quickly as possible. And it was even put on sooner than older cases.
There are 3 older cases that are older than Mr. Hardeman's case that have yet to come to trial. And as a matter of fact, as the court is well aware, there is even a case that has been around for almost 3 years, which the state has repeatedly requested to be placed on a trial calendar, the Romy Bradford case. So, and that case has yet to be set down for a trial date certain. So the state was very concerned, and the defense is entitled to file a speedy trial demand at any particular point in time that they wish to do so. They had not filed a speedy trial demand, and the state felt because of the witness issues, we needed more time to make sure all of our witnesses were in hand and served. So we appreciate the court giving us...
And you did have messages from one of the witnesses you're looking for.
Oh yes, he called up and basically said, I know you're looking for us. I am not coming into court, I'm not testifying. So there is a big problem with obtaining those witnesses. Your Honor, it's not unusual for people to not want to come into court and testify because of the intimidation factor by someone who's obviously committed a murder. They don't want to come in and be seen and testify against that person. It's not unusual.
I do feel like, Mr. Hirsch, we've been over backwards to give your client a quick trial date. And I'm sorry it hadn't come to fruition. However, this is a situation based on the status of these witnesses that I would be concerned about witness intimidation.
May I be heard, Your Honor? Your Honor, of course, the factors in considering bond, it seems like the one that the state is keyed on is witness intimidation. This is actually a case where it seems like it is impossible for there to be any witness intimidation. But before we talk about probabilities of witness intimidations or possibilities, there has to be some affirmative evidence that my client will intimidate witnesses or had tried to intimidate witnesses. My client, Your Honor, I believe the warrant for his arrest was on December 22nd. He, through his attorney, negotiated a turn-in date right after Christmas, and he turned himself in on the 26th of December. Since that time, he has had no contact with any witnesses in this case, any of the eyewitnesses. 1. 2, there is no allegation that he or anyone through him has had to try to have any contact with any witnesses in the case. 3, the witnesses in the case, as far as we can tell, Your Honor, they don't know each other, and there's no allegation that they knew each other other than they're in the same industry and they met at the site, the crime scene, on that day. 4, there are no witnesses to be found. The state can't find them. So with all their resources, with the Atlanta Police Department, with their 60-some investigators, they can't find them. But yet somehow there's this amorphous theoretical claim that Vincent Hardeman is going to intimidate them without any evidence.
We can't try the case without those 2 witnesses, right?
Yes, they're very essential witnesses.
Point being, Your Honor, they're not around to be intimidated. It's not like they're living at a certain address. They're hiding from the police.
What is the defendant's record?
Your Honor, we have the incident down in Miami for the theft by receiving stolen auto charge, for which he took a first offender. Then, if the court will recall, on April 27th of 2011, he pointed a handgun, the FN, at his live-in girlfriend at that time and her 16-year-old daughter. And at that point in time, she called 911 screaming hysterically. The police showed up. They were unable to find the gun. However, they did take the FN case and the ammunition that was with it, and that is in evidence. And FN was what was used to kill Mario Hamilton. The defendant pled guilty to those charges, and we have served defense counsel with notice to impeach the defendant with his prior felony conviction should he take the stand and testify at trial.
When could we try the case?
The defense is requesting is there's no evidence at all that he's a risk of intimidating any witnesses. Plus, it seems impossible to do so since they can't be found. But that begs the question. There's no evidence at all that he's going to intimidate anyone or will intimidate anyone or has tried to.
Do you have any evidence of that, counsel?
No, Your Honor, but there are 4 factors why we oppose bond. Number 1, the defense has put up partially a defense of self-defense. That means he admits he had an FN, pointed it at another man in a crowded hallway, and pulled the trigger with complete and utter disregard for the 30 people standing there, shot a man, turned around, and walked away. Didn't call the police, didn't do anything someone who was really in fear of their life from this group of people would have done. So total disregard for human life, admits shooting another man, in possession of a firearm. All of his tweets prior to this were, oh, hey, I'm pulling up on a roadblock and I had to throw my gun out the car. I guess I'm going to have to go back for it later. We've served the defense with those sorts of tweets. So this is someone who has no problem obtaining a handgun, pointing it at people, and shooting in a crowded room. So therefore, likelihood to commit additional crimes. Likelihood of conviction. I think the state's got a very good chance of getting a malice murder conviction on this case. Likelihood of fleeing the jurisdiction. Why not? He has resources, his whole entire family, and a lot of people sitting behind him. Why should he stay here to face these charges? He can flee the jurisdiction. No, not a problem. So not only is it intimidation of witnesses, Your Honor, but it's all the other factors here that we've got to go ahead and factor in. You know? And Your Honor, there is intimidation of witnesses, and then there's subtle intimidation of witnesses. And that would also include a lot of things that the defense has served on us, which includes lots of people posting different things to different websites. After the last hearing, where the cameras were here, lots of people posted lots of different things to websites that were viewed. Rapper websites, hip-hop websites, with their opinions about the cases and what the witnesses should and should not do. Now, is that Mr. Hardeman's doing? No. I don't know who's doing those sorts of things, but they were for the benefit of Mr. Hardeman. So there's intimidation by him directly, and then there's subtle intimidation. So, Your Honor, we would oppose any sort of bond based on all those grounds. Likelihood to flee, going to go ahead and commit additional crimes. Obviously,
well, one murder case where I allowed a bond backfired on us, Juanita Godwin, who committed more crime. I think that we have bent over backwards and given you the crime is not even a year old, and we have given you a quick trial date. And so what date we talk about? February 18th? And what I have said is we're going to trial whether or not the state can find those witnesses or not by then.
Yes, Your Honor, I understand that was part of the condition for the
continuance.
court. The continuance was, that's the day we're going to have to put it up.
All right. I'm disturbed by these postings. Well, then tell me what that is. The video that's shot here is posted online somewhere?
This video gets co-opted by a lot of different places. After the last hearing, we found it on different rap and hip-hop websites where people are allowed to anonymously post under anonymous names anything they want to post, which is stuff about Mr. Hardiman, stuff about the victim, stuff about the witnesses. And a lot of people look at these different posts because they want to see the video of what actually took place in court. So, Your Honor, we're very concerned about that sort of subtle intimidation in the community because, Your Honor, the problem with a lot of young people today is it's a no-snitch policy. The whole policy on the street, and actually I'm quoting Mr. Hardiman here in one of his rap songs, is the code on the street is silence. You don't talk about it and you don't tell. And the problem is that robs decent people like Miss Wallace of justice for her young son who did absolutely nothing wrong that day.
All right, I think the compromise is this quick court date, and I'm going to deny bond.
Thank you.
So let's set it down for the 18th of February. Thank you.